The intent with introduction of this bill, now an act, is a multi-pronged attack on several issues. Whenever a new law is being enforced or introduced, there has to be a certain window for discussion. All of that is missing in this case.
Do you see users now, let's say, moving on to offshore markets or underground markets where there is a higher risk of them actually engaging in money laundering?
So I don't know how the government will justify that the provisions are in furtherance of those goals
Right.
when it is actually driving away from those goals.
But what do you think the future of the gaming industry is? Hello and welcome to In Focus. I'm Aratrika Bhaumik. Parliament passed the Promotion and Regulation of Online Gaming Bill 2025, which introduced a complete ban on online real money games where users place monetary stakes in the hope of earning profits. On August 22nd, President Draupadi Murmu accorded her assent to the bill, officially giving the bill the force of law. The government has defended the legislation on the ground that there are heightened national security concerns as well as real social risks. However, this billion-dollar industry has long relied on the judicial recognition of the skill versus chance distinction. The industry has also questioned whether an outright ban is the right approach, considering the union government's prior stance, where it has maintained that such an industry will be governed only by self regulatory mechanisms. To discuss the constitutionality of this new law as well as its wider implications, we are joined by Deepak Joshi, advocate on record at the Supreme Court of India, as well as a qualified chartered accountant. Mr. Joshi, welcome to In Focus.
Thank you. Thank you for having me.
Now, this law has completely caught everyone off guard, especially the industry. If we could start off this discussion by discussing about what the intent of the union government was. Now, we have seen a consistent stance of the government wherein they have advocated for self-regulatory measures, right? We've had the 2023 amendments to the IT rules 2021. We've also had a prior 28% GST levy on this industry. So can you just kind of walk us through what the intent was in the first place?
So the intent with introduction of this bill, now an act, is a multi-pronged attack on several issues. Number one, they've cited national security as one of the concerns. Underlying concerns being the prevalent money laundering exercises and also the fact that it has a disastrous consequence on the mental health, financial health and the public order in the general youth of the country. At least these are the 4-5 points that are very, very evident from the bill and the speech of the Honorable Minister. So they've sort of tried to tackle every bit of this concern and the problem in one bill and try to give a one-shot solution to every kind of problem.
Okay.
Now, as you've rightly pointed out, previously there was also a 2023 amendment to the IT rules. There's also a GST applicability. But please bear in mind that merely an applicability of a GST or a tax levy does not mean that the activity is legal or illegal.
Right.
So there was always a loophole as far as that is concerned.
There's always a regulatory void.
Absolutely.
Right. But I mean, do you see, let's say, a violation of legitimate expectation on the part of this industry, which had taken commercial decisions on the basis that the government would not change its stance? So do you see that being a ground for challenge?
Not strictly, but yes, it can be covered in one of the grounds because our country has a national legislative policy which mandates that whenever a new law is being enforced or introduced, there has to be a certain window for discussion to be
Right.
provided to the stakeholders and the affected party. And that window ranges from 15 days to 30 days. There has to be a draft which has to be circulated in the public domain for public consultation. All of that is missing in this case. In fact, everything just happened in a span of 2 days. And within 5 days of the bill being passed by the parliament, the Honorable President has also assented to it.
Right.
So the speed with which it has been passed, enacted, leaves some grounds to be agitated, at least on the fairness of the proposal and the way the process has been handled under the larger umbrella of the national legislation policy.
Right. And just to clarify for our viewers, this law has not been enforced yet, right? It will only be enforced through a gazette notification.
Absolutely.
And will that depend on, let's say, the formulation of the authority, the designated authority?
So yes, you already have the substantive provisions in place, but you
Right.
don't have the machinery provisions enacted, in the sense that there is no designated authority, which is envisaged in the bill. There are no rules framed, which there is a designated authority will enforce. So this is a stepwise procedure. As and when those steps get completed, finally we will have a enforcement notification, as you've stated,
Right.
coming into the public domain, and the act will then be enforced
Right.
with all the penalties.
And is there any clarity on the timeline? Like, has a METI in its press briefings or otherwise clarified on, let's say, whether it's going to happen in the next 6 months, 7 months?
There is a speech in the public domain by the Honorable Minister. As per his expectations, around 3-4 months is what he says
I see.
it will take.
A lot of experts have also flagged that this is not a proportionate measure, which is the judicial standard for assessing any kind of restriction on fundamental rights. What is your opinion on it?
So, this is concerning the doctrine of proportionality. The Supreme Court has time and again read into various legislations the doctrine of proportionality and tested the validity of those acts. It's a four-pronged attack on the validity of the act. You have to test it on the basis of, number one, whether there is actually a valid goal to be achieved by the parliament, and secondly, whether those provisions of the act they are in furtherance of those goals. Now I halt for a moment here. This is step 2. When you go through the act, what the act essentially does is only one word: prohibition. And the experience in this country has always been that the prohibition pushes the activity underground.
Right.
It really doesn't tackle the problem.
Right.
So the goal is to tackle the problem. So I don't know how the government will justify that the provisions are in furtherance of those goals
Right.
when it is actually driving away from those goals.
Right.
The third and the most important bit is that whether the parliament has considered any alternative or least restrictive measure as compared to those contained in the act.
Right.
For example, outright prohibition is one aspect, but the other alternate and the least prohibitive could have been a licensing regime,
Right.
a self-regulatory regime.
Right.
Surprisingly, all of this was always envisaged by the previous iterations of the government itself, Law Commission of India,
Right.
Niti Aayog reports.
Right.
All of them have actually favored self-regulation, regulatory measures, and licensing.
Right. And even if it's not self-regulatory, if you look at other jurisdictions, we have seen other less intrusive measures, let's say monetary limits, anti-money laundering compliances, even parental controls for that matter, which was absolutely not considered at all here. And you bring up a good point, which is enforcement. Do you see users now, let's say, moving on to offshore markets or underground markets where there is a higher risk of them actually engaging in money laundering? Because we have seen how a lot of these gaming companies continue to operate despite prohibition, right? Whether it's mule bank accounts or having mirror websites. So how reasonable is it to expect that such a ban is going to actually be enforced?
Quite apart from the user indulging in these so-called activities, the minister has also categorized it as user being a victim of these games, So the ban actually victimizes the user more, because now the user is susceptible to shady websites which operate outside the territory of India. And you have all these dark web websites where a simple innocent person maybe, just walk into a fraudulent website, do a fraudulent transaction and lose all his money. As compared to a regulatory regime where all of this would have been within the control and the regulations of the government of India. Everything would have been reported, the PAN numbers, the accounting details, the flow of transactions. As you've said, any anti-money laundering compliances would have been done, KYCs would have been done.
Right.
It would have safeguarded the user more.
Right.
So that's not the case here.
And do you also see, let's say, an Article 14 violation? Because in our country, we have states which have permitted, let's say, the operation of casinos, other games involving monetary stakes like horse racing. What is the reasoning behind, let's say, criminalizing this sector vis-a-vis other games which already have monetary stakes involved?
So you're right. The direct Article 14 challenge is when you compare the same money games, so to speak, offline, and now you compare to the same money games online. Offline money games are still valid, they're going on. Online money games, only because of the virtue that they are operated on online ecosphere through a computer or a network, they are banned only for this reason. And perhaps the thinking of the government is that the use of technology actually expands the reach of these games, and to that extent they are more dangerous for the society, and it's not easy to control them or regulate them because of the technology involved as compared to an offline game. That's a direct Article 14 challenge.
Right.
But within the act itself, when you compare the definitions and the safeguards provided, there is another layer of Article 14 challenge. For example, the act now categorizes and recognizes three categories of the game. One is esports, the other is online money games, and the third is social gaming. Out of these three, two have been accepted.
Right.
And one of them being esports.
Right.
Esports, one of the key criteria is that it should be solely based on the skills and no wagering allowed. Now, whereas online money gaming has been prohibited totally, irrespective of whether it's on skill or chance or a combination of two, only on the basis that some money stake or some wagering or some betting is involved.
Right.
This false distinction only on the basis of some money or wagering or betting involved goes contrary to decades of jurisprudence laid down by the Honorable Supreme Court.
Right.
It's not the money or the wagering which decides whether the game is a game of chance or a skill.
We've had so many Supreme Court judgments as well as High Court judgments which have actually categorized certain gaming companies in this sector as constitutional because they have said that predominantly these are games of skill and not chance. So what exactly happens to these rulings now? Does the law invalidate all these rulings?
So this is not one of those laws where there exist laws where you have a provision that irrespective, notwithstanding any law made by any other state or any ruling or order by any court, this will follow.
Okay.
This provision is absent in this law. So it doesn't invalidate those laws. And you have to also consider that the jurisprudence led by the Supreme Court is not merely instructive. It has a basis in law and reasoning. When they say that games of skill have the protection of the Constitution, what they simply mean is that you and I have a specific skill. Let's say we deal in cards and those games of cards where skill is necessary. And we've acquired those skills. Then we can exploit those skills.
Right.
And win money or even have a profession out of it.
Right.
But compare them to games of chances. There's no skill involved or very less skill involved.
Right.
And it's all up to the hands of the Almighty. Of course, there is nothing to be exploited. It's all mere chance and it's more closer to betting and gambling. That's where the Supreme Court has drawn the line.
I see.
This line has been obliterated in this act.
Right.
There is no differentiation between a game of skill and a game of chance. Both have been prohibited and kept in the same class.
Right.
So unequals have been treated equally. This is another facet of Article 14
Right.
to that extent.
So this would also constitute, let's say, then a violation of Article 19(1)(g), which is freedom to practice one's profession or trade. Now, what happens to the companies, online real money gaming companies, which were held to be lawful by the Supreme Court in its prior verdict? Let's say Dream 11, which won a challenge. So what happens to that right now?
Unless the law gets stayed, on the date that it gets enforced, their activities are prohibited.
Right.
And they will not be allowed to carry out these activities. Any funding or any transfer of funds that happens in respect of these games, that will also be prohibited and they'll be visited by penal consequences, both in terms of financial as well as criminal consequences.
And since we're discussing Article 14 violations, in your opinion, is it correct to presume that, let's say, an offshore online real money gaming company and another company which has its offices in India within the jurisdiction of India, they should be treated alike? Because in this case, both have been treated alike and both have been criminalized. Especially because why I say this is because, let's say, an offshore gaming company would not be under the direct control of our investigative agencies. So do you see this as also a case where, unequals are being treated equally?
You're right there, because the act is actually extraterritorial in its nature. There is a particular clause which specifically says even beyond the boundaries of India. But you also have to bear in mind, you've rightly pointed out, how will you work out the compliance part of the law in respect of those entities which operate outside the domain and the territory of India? Apart from that, they are not the subject matter of the local laws in India.
Right.
So even if they are not complying with any PMLA or any banking regulations of India, they are not doing anything illegal. They are operating outside India. They are merely providing their service on a server which is accessible from India.
Right.
And perhaps that is the reason why those blocking provisions have been brought into effect in the Act, where the central government has been given a power to block any content, any data, any server, which goes contrary to the prohibitions contained in the Act.
I see.
Yeah.
I see. The other question is, and something that has been debated a lot, is the legislative competence of the union government to introduce this law in the first place. Now, betting and gambling is a state subject under entry 34 of the state list. However, what the union government has said before in its press briefings, the METI secretary, Mr. Krishnan, is that the power of the center with regards to this law arises from entries 41 and 42 of the union list, which is essentially interstate trade and commerce as well as broadcasting and communications. So what is your opinion? Do you think it's a valid ground?
So if you see it objectively, this law is a prime example of something which the Supreme Court calls ragbag legislation. It picks certain aspects from different entities, collates them, and presents one law, composite law, so that when it gets challenged in the court of law, they can take support of one entry or the other, shift their stance to defend the validity. Now, there is a test developed by the Supreme Court to defy such maneuvers of the parliament, which is called the doctrine of pith and substance. Simply speaking, you have to go to the root of the law and see, in effect, in truest sense, what is it pertaining to. Now, can you objectively say that this law, the current law that we are discussing, pertains to broadcasting, information technology? In my limited reading of the law, the answer is no. Does it pertain to interstate trade and commerce? The answer is no. The truest form and the effect is only on gaming, betting and gambling also, which is the domain of the state law. So to that extent, legislative competence challenge is also alive, and it will be challenged before the courts, whether the High Court or the Supreme Court.
Right. And like you mentioned previously, you also have a host of state laws, right? You also have states undertake licensing regimes, like Tamil Nadu, for instance. So what happens to these regimes now? Because they are clearly now the legislative power has been assumed by the center.
So just to answer that, I would also highlight one of the preambles and also the notes to clauses given in the bill. It has specifically written that the parliament is assuming legislative competence because of the nature of the industry concerned. Now, this also relates to some other entry in the list one, which is entry number 52.
Okay.
This gives the union an upper hand as compared to the states. They merely by law have to declare that they find it expedient in public interest to take control over certain industries, irrespective of whether those industries are state subject matter or not. However, having said so, this is a debatable issue now, because the issue directly concerns the federal principles under the Constitution of India. If there is a direct power with the state, and they are exercising that power by virtue of regulating these games and earning revenues out of those regulations,
Right.
then how can the union eat into that space of the state? So both the union and the state will be at loggerheads, in my humble opinion, on this aspect.
Right. So we have to see how it plays out in court.
Absolutely.
Now, if you could discuss a little about certain provisions. First being Section 16, which allows central government designated officers to undertake search as well as arrest without warrant. Now, we've seen a similar provision in the new income tax bill. Do you think this raises civil liberty concerns as well as constitutional challenges?
So similar provisions are now being regularly incorporated in these economic offenses or similar kind of laws. The underlying assumption of the parliament is that there was a Supreme Court judgment way back in the 60s and the 70s which says that privacy is not a fundamental law, a right of the citizen. That has been overturned
Right.
by the Supreme Court larger bench in Puttaswamy judgment. They don't recognize the effect of that judgment. Now, all these carte blanche kind of search and arrest provisions without warrant, including the privacy, they have to be tested on the proportionality principle, on Article 14 principle. Because if you see the clause that you've referred to, it has a very vague term that if it is reasonably believed that certain things are happening, what is the meaning of that term?
Right.
Will the concerned officer lay down the grounds why he or she reasonably believes? What is the reasonability? To what extent? And also the right to privacy.
Right.
To what extent can that be obliterated in this act?
Right.
So this issue, along with the other similarly situated laws, will definitely reach the Supreme Court. And more so in view of the Justice Puttaswamy judgment.
Right.
So in my view, this vague clause is clearly unconstitutional on that measure.
Right. So what the METI Secretary Mr. Krishnan had mentioned is the reason why we have allowed such a clause to exist in this bill is because these offences have been classified as cognizable, which is why, I mean, his reasoning is that is why the investigative agencies can arrest and can search without a warrant. So how would you respond to that? Because this is the official reasoning taken by the ministry.
So that's a circular argument. Even if it was not cognizable, they could have always taken a permission of the magistrate and proceeded ahead to conduct searches and arrest the concerned accused. In fact, the new criminal laws have that provision that you have to take permission from the concerned magistrate to seize certain aspects of the assets of the person or even go and search certain premises of the person. Similar safeguards could have been built into explicitly in the law. They did not do so. I don't know why.
Right. And the other aspect is Section 17 of the Act, which allows again central government designated officers as well as the regulator, which is going to be designated under this Act. It provides them legal immunity from any proceedings undertaken in good faith. That is the term. Do you think this is too broad a discretion and immunity given? And also something that I'm really curious to know, why wasn't this, let's say, legal immunity extended to state government officials? Because you will also have the state enforce this law.
Absolutely, absolutely. In fact, the search and the arrest provisions that you've mentioned, they have a provision that even the state officer can be a designated officer. So the similar provision, protection of Good Faith Act is not extended to them.
Right.
So that's a glaring loophole in the Act. However, these good faith protections are normally part of any law enforcement agency that you observe. And this is nothing out of the blue that I see. Of course, it will always be tested in the court of law whether any act or enforcement action done was during the course of the duty. If it was beyond the course of the duty, this protection, in my humble opinion, will not apply.
I see.
So because it was not in good faith and not in course of the duty. It was malified and beyond the call of duty.
Right. Also, understanding the categories of companies which would fall under this prohibition. Now, I'm just curious, if you go on Swiggy or Zomato, a lot of times they have this spin the wheel contest, right? Where there is no direct monetary stake involved, but you do get a benefit. You either get a cashback or you get some form of a discount.
Yes.
So what happens to these promotional activities now? Because the phrase mentioned is also other stakes, which doesn't necessarily have to involve money.
Correct. One way to deal with this position is you're not playing a game when you enter into Swiggy or Amazon kind of apps. The purpose is not gaming. It's just those benefits that you get out of shopping. So these are not stakes, so to speak. But I want to take you to a parallel example, which will definitely get impacted. In many of these now, esports, for example, can be an online football tournament, online cricket tournament, online chess tournament, right? And in many of these gaming tournaments, you give a participation fees and you play according to your skills and win the prize. But you also have certain chance based cashback packs or rewards. What will happen to that? Because that's purely chance based. For example, if I've scored 5 goals, I'll have a 200 rupee bonus. Or if I've tackled someone, my goalkeeper has saved this many goals, I'll get 1,000 rupees cashback. This is completely chance based. Now, strictly speaking, then if this is chance based, then you're outside the scope of esports.
Right.
And you fall back into online gaming.
Right.
What will happen then? So this is the vagueness in the law, undefined terms in the law.
Right.
This is another Article 14 challenge.
Right. And hopefully we'll get some clarity once the rules are notified. We'll have to see whether it really addresses.
So the scope of rules also is a little deficient in the law.
Okay.
If you see one of the provisions, it says that the central government or the designated authority will respond to certain complaints by users if it is prejudicial to the interest of the users.
Okay.
There's no scope or reference to any rules framed for that procedure.
Right.
What is the procedure? What is the safeguard? Will a hearing be given? Who's the appropriate authority to approach? What is the timeline?
Right.
There is another provision that any order of the central government will be binding on all the stakeholders. Under what provision of law, under what rule, the mechanism will follow?
There is no clarity as to whether an opportunity to be heard is going to be meted out. And of course, even on the IT rules, we have seen how the blocking regime, how opaque it is. There has been so many challenges and concerns that stakeholders have raised. So we'll have to see whether the same follows. It'll be unfortunate if it does.
On that aspect, the provision is really not clearly worded. At one point in time, it ignores specifically mandates that notwithstanding Section 69A, irrespective of Section 69A. One reading can be that any protection, whether judge made or in the rules of the IT Act, for example, there are blocking rules of 2009, those provisions will not apply. Those safeguards will not apply.
Right.
But then there is also a provision which says that any procedure prescribed under the IT Act will have to be followed.
Right.
So there is inherent contradiction in the provision.
Right.
So this is another problem.
Right. The last question being, what do you think, in your opinion, would be the implications for this sector? Of course, they have been severely impacted. They have consistently maintained that there has been no stakeholder consultation which has been carried out. And we've also seen companies like Dream 11 go into other ventures. They have shut their operations when it comes to online real money gaming facilities. So how do you think this sector is going to move forward? And of course, depends, I'm sure, on a challenge or the outcome of the challenge. But what do you think the future of the gaming industry is?
Purely from a commercial angle, unless a company is able to pivot its business model to something which is in compliance with this act, it will have no option but either to challenge the law in the court of law or to shut down its operations. Because now the model was you pay to win something. Now that's been completely prohibited. Now the alternate model which is allowed under the act is that you pay to participate, and if you win something on your own, on your skills, purely on your skills, then that is allowed. In-app purchases or in-app gaming is again a gray area. So it's not going to be an easy commercial decision.
Right.
Most people, if they have no other alternatives, if there is no funding, if there is no FDI in that company, will have to shut down the shop.
Right. And you also have, plans of the center to impose a 40% GST on this. Sin goods, that's what they are referring to. So that would also kind of curtail their financial capabilities by far.
And you have a live case in the Supreme Court pending on the applicability and the valuation of GST on online gaming.
Right.
So that is still sub judice in the Supreme Court. So that will have its own ramifications, and I'm sure those ramifications will also apply to the act.
So what would happen to this proceeding now? This ongoing proceeding when it comes to levy of GST on this sector? That's already currently being heard.
Absolutely. But this law has no implications on that.
Okay.
But the debate of games of skill versus games of chance is debated in that proceeding.
Right.
Whatever is the finding, the Honorable Supreme Court will have to give some findings on the nature of game of skills and game of chance.
Right.
And those findings and those observations will definitely apply to the present law.
Right. And the challenge, of course. Very
Absolutely,
important.
in that light.
Right. Thank you so much, Mr. Joshi. This has been a very, very insightful conversation. Thank you for joining us.
Thanks.